The July 13th meeting of the Compliance and Amendments Committee of the Sunshine Ordinance Task Force is now called to order. Chris, would you read the roll call, please?
Yes, Madam Chair. Member Washburn?
Present.
Washburn present. Member Goldman? Goldman excused. Member Nee?
Here.
Nee present. Member Snyder?
Here.
Snyder present. Member Wolf? Wolf excused. Madam Chair, there is a quorum.
Okay, Chris, would you call the first order on the agenda, or first item on the agenda, please?
The first item on the agenda is the approval of February 9, 2010 meeting minutes.
Move they be approved. Second.
I have a couple of small edits that I can. I think there are just a couple that maybe should have some discussion. One is the bottom of the last line on page 2 of the minutes, page 5 of the packet. I believe it should read, "There was nobody in the audience to present facts and evidence in support of the respondent." And the same on page 4 of the minutes, under item 7, third paragraph, same thing. It should be respondent instead of complainant. The other was also on page 4, the 4th paragraph down. I'm wondering about the term. Is it digitalize or is it digitize?
I believe it's digitized.
So, Chris, if you could check that, I think it's digitized as well. Are there any other changes to the minutes?
I would just one suggestion at the bottom of the minutes under adjournment. I believe usually there's a notation on the time and place of the next regularly scheduled meeting.
Okay. Could you indicate that?
Isn't that the practice?
Through the chair, that practice is only on the agendas when the next meeting is going to be.
It's not. Oh, it's not on minutes.
Not on the minutes.
Okay, that's fine.
Okay. Is there any public comment on the minutes for February 9th? Seeing none, Chris, would you read the roll, please?
On the motion, Member Nee?
Aye.
Nee, aye. Member Snyder?
Aye.
Snyder, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, there are 3 ayes.
Chris, could you read the next item on the agenda?
Item number 2 is the approval of the March 3rd, 2010 meeting minutes.
Madam Chair, I don't think that this body of minutes is ready for approval. The reason I say that is that on page 3 of those minutes, page 12 of the packet, toward the bottom, the very last paragraph from item 1 says public comment, Peter Warfield and Alan Grossman. Mm-hmm. It does not indicate what they said, right, and right. I think that should be included. So right. I would move to continue this until our next meeting.
Yeah, I noticed the same thing, that we need summaries of their comments.
Without objection?
Without objection?
Yeah. Public comment.
Or is there any public comment on the minutes from the special meeting of Tuesday, March 3rd? Seeing none. Chris, would you call the next item on the agenda?
Item number 3 is approval of March 9, 2010 meeting minutes.
Move to approve. Second.
I had one question. The bottom of page 2 of the minutes, page 15 of the packet, there's a statement that extends to the next page. It says, members suggested some changes to the language in the proposed amendments and were accepted without objection. So I'm assuming these are very minor edits. Otherwise, I think they should be indicated here.
Agreed.
Chris?
Madam Chair, I think that document relates to what you had suggested, the corrections, that the full stops and it's just minor
These were
corrections.
not substantive changes.
Not substantive.
I think the minutes should reflect that these were not substantive changes, minor edits.
Okay.
That should be a part of this.
Also, insert the word those on page, top of page 3 of the minutes, 16 of the packet. Insert the word those between and were. So it said, and those were accepted without objection.
Is there any public comment on the minutes from special meeting on March 9th? Seeing none. Chris, could you call the roll? Or do we want to continue these until the next minute or next meeting, or can we, given this minor change, move ahead?
I would say since it is a substantive change to the minutes,
Oh,
it's probably a good idea to continue.
okay.
So I would withdraw my motion to approve. And if the second will withdraw, I will withdraw my motion to approve and ask for a continuance.
I'll second that.
Okay, without objection,
Without objection.
we'll continue this. All right. Chris, could you call the next item on the agenda?
Item number 4 is hearing on the status of the June 22nd, 2010 order of determination in Selvlana, Patashnaya, and the Department of Adult and Aging Services.
All right. Ms. Tashnaya, you have 5 minutes.
Good day, thank you. I received information, I believe you know already, you received a message that was forwarded to me, thank you, from DAS department. It's nothing else like next refusal and breaking the law. Now they break the law towards order of determination. Literally, any records related to an adult protective services investigation are not public records and are protected under some code and sections. As I believe, it's nothing like as a false statement. They repeat to state on the false, true, and opposite. And now it's not toward my request, it's now toward order of determination. I received nothing that, else that I had before, my letters and the responses of same kind, no new information. As I understand, it's government organization, all their work are open for public. I'm a member of public, and I was entitled most immediately to have records of their investigation. And one more I want to underline, to ensure you, I would never allow some person who I don't know to go to be in my apartment to discuss subjects that I consider nothing else than criminal activities of some group of person. If I would never allow this person to come at my apartment if this person wouldn't introduce himself as government employee. He contacted me on first place, called me, and asked to discuss situation that I consider as criminal activities close to my apartment. I would never allow him to come to my apartment if he wouldn't introduce himself as government employee. He came at a place where I live, tried to harass me, tried to perform, obviously for me, he broke his duties, rules, and broke, I believe, criminal law as well. I am not authority to investigate this. I ask for your help again. Thank you for every minute of your help, sincerely. Thank you very much.
You're welcome. Is there anyone else present who can present facts and evidence in support of the complainant? Seeing none, is the respondent present from the city?
Good afternoon.
You have 5 minutes to present your side of this case.
My name is Cindy Rasmussen. I work for the Department of Aging and Adult Services. And there is nothing I can say other than the fact that all of the documents have already been submitted to you, and there is nothing further that I can add.
Are you saying that all of the records pertaining to the investigation of the employee have been released?
Everything that has been submitted to you that we have has been already submitted to the committee. APS records are confidential and are protected under the Welfare and Institution Code and cannot be released.
Okay, but those are two separate things. I mean, are you saying that there are records which you can't release and therefore aren't providing them to...
Point of order.
Sorry.
Questions come later.
Oh, sorry, my bad.
I really can't speak to anything else, so I'm just here to sit in the audience and represent the Aging and Adult Services Department.
Okay, is there anyone else here to present facts and evidence in support of the respondent?
Hi, I would like to add, my name is Pamela Tebow. I'm with the Human Services Agency, and I just would like to add that this request has been going on for some time, and the Aging and Adult Services Department have provided all the documents that they can legally to Svetlana, I believe her name is. I'm sorry if I'm mispronouncing
Microphone, please.
it. Yes, and they have provided all the documents that they can legally provide to her. And they have sent you a copy as well. Thank you.
All right, the matter is now with the task force for discussion and further questions. Member
Ms.
Nee?
Tashnaya, could you please approach the microphone? No, that'll come later. I do have a question. Please approach the microphone. I do have a question for you.
Thank you, sir.
We have received certain additional information today or yesterday. These are copies of these are copies of documents that were sent to you. Now, as near as we can tell, and you will confirm or contradict, the documents that were sent to you on July 9th are documents that were sent to you on July 9th. Those are documents you already had, is that correct?
It's correct, sir.
Okay, and from your perspective, you have still not received the documents that you had requested that are the genesis of this complaint, is that correct?
None, not a word.
Okay.
One second. In this document that I had previously, the same, nothing new I received.
Nothing new?
Nothing new from I had before I addressed my complaint to you. Nothing new. Among these documents that I had previously, there is a statement that investigation took place. Investigation took place. It's in these documents. And nothing else, no one words besides this I have about this investigation. Not previously, not now. And
Okay.
it has nothing to do with any closed records. It's investigation of government employee about his behavior during performing his duties as government employee. That's it.
Okay, and you have not received any records relating to your complaint against Ethelbert Ogbuhi, is that correct?
I received only a letter that stated that investigation took place and was closed. And they continuously refused to open results of investigation.
Right.
That is essence of my request.
Thank you.
Thank you.
Member John, or
Could I ask, Ms. Rasmussen, could I ask you a question? First, thank you for coming today. I apologize, I got ahead of myself earlier.
That's okay.
So my question is, are you saying that there are no more records you can provide regarding the investigation into the employee that the complainant is seeking? Or are you saying that you've released all that you believe you can release under the law? Those are two separate things, if you understand what I'm getting at.
I think I do. There are no other records. The information regarding the complainant's requests are part and parcel of an APS case, and that is protected information that cannot be released. It was involving an active Adult Protective Services case that was open. And those interactions are part of the APS case record and cannot be revealed,
Okay,
cannot be released.
and I don't mean to be pedantic here, but you're saying kind of two separate things. You're saying there are records about the investigation which you
No,
can't...
I'm saying there are interactions that were involved during an open Adult Protective Services case. That is part of the APS case record. There are no other files or written information.
Other than the APS
Correct.
case record?
Correct.
Okay. But there are records in what you're referring to as the APS case record. There are records there, but your contention is that those cannot be released under the statute.
Those involve an active Adult Protective Services investigation, and that is protected information under the Welfare and Institutions Code. It is inextricably involved in the case itself.
Okay.
So it's part and parcel of the case.
Okay. But that's different from saying that there are no records, that there are no more records that
There are no other records other than those within the Adult Protective Services case file.
which you're saying are protected.
Correct.
Okay.
I'm sorry, did I confuse you before?
No, I think I
Okay.
understand now. What I thought you were saying initially was that there are records, there are no more records, period. If we could produce everything, there are no more records that we could produce. But what I hear you saying now is that there are records in the APS file. It's just that those records are not releasable under the State Welfare and Institutions Code.
That is correct.
Okay.
Member Nee.
The records you're talking about do contain references to the complaint that Ms. Patashnaya has filed against Mr. Ogbuhi. Is that correct?
I don't know if I can answer that. I don't know if that's really confidential. I'm not at liberty to discuss
Well, no,
what's in
I'm
the
not so sure
APS
it
case
is.
record.
I'm not so sure it is because it seems to me these are two separate issues we're dealing with here. You know, Ms. Patashnaya is not asking for records dealing with the she's dealing with the record. She's not asking for information that you cannot release. What she is asking for is information regarding the investigation into the conduct of Mr. I hope I'm pronouncing this correctly, Mr. Ogbuhi toward her personally in her residence. Those are separate things. Even though they might be on the same record, they're separate things. Am I correct?
I don't believe so. not in this particular instance.
Why,
Because
why not in this particular
Be-
instance?
Well, again, I'm not at liberty to discuss anything that surrounds any APS case. And this interaction surrounds and was involved in an Adult Protective Services
Okay,
case. So I
but-
can't comment on any of her allegations or, what the case file entails. I can't speak to that.
But could you not release the information she seeks, separating it from?
It isn't separated from, it is
But
part.
can it be separated
It
from?
cannot.
Can you release what she is seeking and redact what is not releasable?
It is part of the APS case record.
That you didn't answer my question. What I'm
I don't
asking
know
you
how
is,
to answer your question.
can you not redact what is not releasable, what is exempt or prohibited from release, and give her the rest of the information that is not exempt?
I don't believe that's possible.
Can I try a question? So is it your position that if it is in the APS case record, whatever it is, whatever record is in there, it is inherently not releasable because of the fact that it's in the APS case record?
And
In other words,
because
if there was a
it's-
copy of the Declaration of Independence and
That's
it was
correct.
in the APS case record, you couldn't produce the Declaration
That
of
is
Independence to us? Okay.
Yes, because it involves the actual investigation that we are required to do per our statutory regulations.
Members, any other? We can just,
Concluding remarks and rebuttal.
or we can further discussion amongst us, right?
We can.
Yeah. No, I just want to say that this is an interesting situation. It seems that what we're hearing is that anything at all in a file of this agency is protected simply because it's in the file, whether or not it's particularly germane to the client. In this case, maybe an older person. And that seems to be the crux of the matter here, because when we had the hearing before the full task force, it was our decision, our determination that information pertaining to the investigation of the allegation by the complainant was about an employee, and his behavior had nothing directly to do with the client, whose information would be protected.
It
So our
does.
determination, our determination was that this was not protected information, which is why we issued the order of determination that we did, in addition to including some other matters, more peripheral. Am I remembering this correctly?
That sounds right to me.
Well, perhaps I can try to clarify that
Excuse
one
me,
point. Oh,
we,
I'm sorry.
Member Nee, is that your memory of,
Yes,
okay.
that's correct.
Can I ask her to elaborate? Can you elaborate? You have something that,
Well, maybe I can try to clarify
right.
that this case record involves a client. And the worker was working on behalf of this client. So all of those records are around that client. So,
but it is your position, is it not, that if an employee of APS downloaded a copy of the Washington Post from yesterday from the internet and put it in the file, that you would not be able to segregate that out and produce it for somebody requesting that?
that, I can't speak to that, but that is not what I'm saying. I am saying that the records that Adult Protective Services keeps that directly relate to a client on our caseload cannot be, released. And that is state regulation, that any record that is germane to a case of a client who has been reported to us is protected. And this interaction was relating to a client of Adult Protective Services. it's not an exterior document that was brought into the file. It's part of the record of our investigation, of our working the case. So I think that's a little different than what you may have thought.
Okay, any more discussion from the members? Member Snyder?
It seems to me that our conclusion the last time around in our order of determination is at loggerheads with the way APS is interpreting the statute. I think what we said last time is that if the information is related to an employee's disciplinary hearing, that it is disclosable, and that information may be segregated from information that may be protected under the Welfare and Institutions Code, if I'm getting that name correct, which I may not be. And it seems to be the position of the agency that if it's in the APS file, essentially it's protected, although later testimony suggests that they believe that it needs to be related to the client. In any event, I don't see that much has changed since the last time around in terms of what the agency believes they can release and what we believe they can release, or what our interpretation of what is releasable was in the order of determination.
That's my feeling too. It seems that nothing has changed in terms of information released to the complainant, and until I hear otherwise from the respondent, I tend to feel the way I did at the full task force meeting, that it seems to me there's information about this particular employee's behavior towards the complainant that could be segregated. True, he was working for their client, but something happened that moved this outside of the strict direct involvement of the client. It's about this employee's behavior. He could have acted much differently and none of this would have happened, but he, in the complainant's mind, overstepped a lot of bounds, which is why she complained. And an investigation took place, of which she's completely in the dark about because she can't get information about it. Yeah.
That's the meeting agenda. Thank you.
We're consulting the ordinance.
My apologies. Trying to get a copy of the ordinance.
Dave,
Yeah,
you can hang on to that for the rest of the meeting. I
Okay.
have another copy.
thank you.
Can I have a copy too? Do you have two copies?
We can share this.
Okay.
This is the good government plan. We can share it. I want to call for the concluding
Okay.
response.
All right. Okay, we've reached the point in the hearing where we hear once again from the complainant and the respondent. I believe the order is that we first hear from the respondent and then from the complainant. 3 minutes each. I'd like to hear, public comment comes after this.
No public comment comes after the motion.
After the motion. Ms. Rasmussen?
I really don't have anything else to add, just to stress that all the information in the case file is protected information and relates directly to the investigation of the abuse that was reported to us. There is no other personnel information or anything else in the case file.
Thank you. Are there? Okay, the complainant, you have 3 minutes to rebut.
I believe organization that has title Adult Protective Services has every work hour, nothing else work with welfare cases. Ms. Rasmussen must be included, I understand. Adult Protective Services have no other work as work with welfare files, as I understand. If believe words of Ms. Rasmussen and her colleague, any activities performed by Adult Protective Services employee now closed for public because they work with welfare cases. It cannot be according to law, and as I understand, and completely against the law. I request information about activities of employee. It has nothing to do with welfare information. If they included investigation, if it really took place as they reported, any records pertains to investigation, if they included in a case that is closed, it's wrongdoing, it must be corrected, and all these records must be open to me, as I believe it's how law says. Thank you very much.
Thank you. Member Nee.
Yes. Under 6724C of the Sunshine Ordinance, pardon my lapse here. 6724C, under information that must be disclosed. 6724C7. The record of any confirmed misconduct of a public employee involving personal dishonesty, misappropriation of public funds, resources, or benefits, unlawful discrimination against another on the basis of status, abuse of authority, or violence, and any discipline imposed for such misconduct. That information is disclosable. And what we are doing here today is determining whether the order of determination that the task force issued following the meeting of June 22nd has met compliance. And I do not see that compliance as having been met. It is up to the respondent agency, when information is disclosable, to disclose it in such a manner to separate it out and disclose it. If there is information that is not disclosable that's part of that record, then it's up to the respondent to redact it, to find a way to redact it, to make sure that no information that should be disclosed is withheld. The respondent has not done that. Therefore, I move that this matter be referred back to the task force for possible referral to an enforcement agency, such as the Ethics Commission, the California Attorney General, the District Attorney, and or the Board of Supervisors.
Do we have a second?
Actually, I have a question or a point of discussion. So the last time around,
Is there a second?
I second, yeah.
Okay.
Can I second and then ask a question?
You may second for purposes of discussion, certainly.
Yes, I would like to do that. My apologies. So, for the purposes of discussion, the task force initially found violations of 6721C, which is requiring agencies to assist in various ways. 6721E, which is sending a knowledgeable representative, because at the hearing before the task force, if I remember correctly, the agency didn't send anybody. They have sent somebody this time. Does that, in your view, Mr. Chair, Ms. Chair, or Mr. Member Nee, alter our finding under 6721E, which is, as I said, sending the knowledgeable representative? I mean, they have sent somebody this time who has some knowledge about their records.
Well, we can, I believe we can determine that, in referring to the, to an enforcement entity, we do not have to cite 6721E. That portion of the compliance, that portion of the order of determination, at least this time around, has apparently been met. So we don't have to make that a grounds for referral. However, I still believe very strongly that the order of determination has not been met, particularly in compliance with 6724C7 and possibly 6721C as well.
And I agree with you on those 2 points. So could I propose a friendly amendment that we refer it back to the task force for the violations of 21C and 24C7, but not 21E?
We can make that part of the, certainly we can make that part of the motion, that the referral would be specifically for those two sections, 6721C and 6724C7. The chair will accept the friendly amendment.
Yes, I will. Okay, now it is time for comment from members of the public on the motion before us.
Hi, Kimo Crossman. I want to say I agree with your proposed motion. I'm thinking of the examples that were discussed earlier. What happens if someone downloaded a Washington Post article that happened to have the name of the person whose case file is named? Would that be disclosable? According to the department, because it has the name of the person in the Washington Post article, then that would not be a disclosable document in any fashion, not even in a redacted form, even though it's public. I'm also thinking that any letters that the initial complaint submitted to the department, her initial complaint, and any letter she sent following up, I'm assuming those also, by the department's own definition, would not be redisclosable to the person who submitted them in the first place, because they're in the case file, and not even in a redacted form. I'm aware of, there is some California case law that says just because you put a document in a file doesn't mean that that it's completely covered by any privilege. I don't have a chance to look it up right now, but I know I've read about it in the past. So I don't think the department's acting in good faith here. They seem to not even understand the idea of redaction and segregation of documents. As we know, Sunshine Ordinance is the highest law with regards to public records in the state, per the Sunshine Ordinance, and with regards to San Francisco records. So even if there might be some state law, the Sunshine can decide to allow for greater disclosure, and that's what's happened here. So I commend the task force, the CAC committee, in their diligence in the matter, and think that they should be found to have committed official misconduct and have that matter referred out to ethics at the appropriate time.
Excuse me, Ms. Thibault? Yes, you you spoke on behalf of the respondents, so
Right. So
you're not eligible to speak
Oh,
for
I
public
can't
comment.
ask again. Okay. Could I ask a question for clarity's sake?
No?
No. Okay, then I don't know that we can actually respond because we're very confused. Maybe I could contact Chris at a later date.
That would be fine to contact Chris, yes.
Members of the committee, Ray Hartz. I was present at the hearing where Ms. Pastanaya brought her complaint. And if I understand this correctly, she is not the member in the appropriate file, which the department is saying they cannot release any information. She is someone who dealt individually with a member of their department and about whom she filed a complaint. And it sounds to me like they have this investigation. They did the investigation, came up with some sort of a summary or a conclusion, and then shoved it in the file. Now, if Ms. Pestishnaya was the actual member, she could waive and she could say, this is my file, you can release it. So apparently she is not. She is some individual who may have been contacted in relation to this case, but her action is a separate issue because it is between her and the city employee who she submits has done something inappropriate. And to simply allow them to say, well, since it is tangentially related, that he came there may be related to this file, we're going to shove it in that file and keep it from her. I think it's just a matter of common law that basically if I file a complaint against a city of employee relating to their behavior and they do an investigation, that I, as the person filing the complaint, should be entitled to know what the conclusion of the investigation was. And I don't think that there is any reason to say that they cannot segregate that and redact if there does happen to refer to the fact that the employee came as a result of the case, they could redact that information as necessary and give her the results of the investigation to let her know fairly what their conclusion was in the relation to their employee's performance in her case. So I think what they're just doing is they're kind of saying, okay, we can shove anything we want into the file, and as long as it's in the file, we can claim privilege. And I don't think that's appropriate, and I think you were completely right. The task force was completely right in finding them in violation, and I think you're completely right in sending it back to them for reconsideration.
Is there anyone else who has public comment on this matter before us?
I think there's definitely a problem. I think the thing is for me, I think y'all need to do something about this because, see, you might find for a violation or whatever, but she still doesn't have her information. So hopefully you can do something, you know, to the Ethics Commission or the Board of Supervisors so she can get her information. I've seen it several times where there'll be a violation or whatever, but she still doesn't get her information. So that's one of my main problems. I think thanks.
Thank you. Is there anyone else with public comment? Okay, seeing none. Chris, could you call the roll, please?
Yes, Madam Chair. On the motion to find violation and forwarding it to the task force, Member Nee.
Aye.
Nee, aye. Member Snyder.
Aye.
Snyder, Member Washburn.
Aye.
Washburn, aye. Madam Chair, we have 3 ayes.
Chris, could you call the next item on the agenda, please?
The next item on the agenda is the hearing on the status of the June 22nd, 2010 order of determination in Suzanne Dumont versus against the Recreation and Parks Department.
Okay, is the complainant here today? Chris?
Madam Chair, the complainant says she was not made aware of the meeting till this afternoon and is not able to attend.
Okay, I think I saw some emails about that.
Yes, it's in the packet.
Right. Member Nee, I have a question. Should we call the respondent, who I believe the respondent is here?
Well, we can do that, or we can ask the respondent if continuance is acceptable. However, if the respondent indicates that a continuation is not acceptable, I think we should go ahead. I believe that when the task force heard this case, I indicated at the time that it would go to this committee, and so I think we can proceed.
Okay. In that case, then, the respondent has 5 minutes to present her case.
Unless the respondent would like
Unless-
to agree to a continuance.
Okay.
Good afternoon. I'm Olive Gong, Recreation Park Department.
Excuse me just a minute. Full microphone? Okay. Please proceed.
Good afternoon. Just wanted to let you know that we received the letter of determination requesting that we provide the complainant with the specific statute involved in reason for withholding our documents, and we had emailed this to Ms. Dumont July 9th, letting her know that withholding documents, we were holding it under Section 6724E1 of the city's administrative code. So we hope that that completes our requirements for this case. That's all I have to say.
Is there anyone here to present additional facts and evidence in support of the respondent? Seeing none, the matter is with the task force.
Just one brief point of order. I suggest that you ask to see if there's anybody in the audience who wants to present facts and evidence in support of the complainant.
Right, I'm sorry. Is there anyone in attendance who would like to present facts and evidence in support of the complainant in this case? My apologies for skipping over this. Seeing none, the matter is with the task force for discussion and questions. I have a question for Ms. Gong. Looking back over this, reviewing this for today, it really was a fairly straightforward matter of you're having to cite the statutory authority, which you did. I guess the suggestion I would have going forward is perhaps a brief explanation would be in order to, as a courtesy to the complainant, just explaining what this is so that this person doesn't have to refer to the ordinance.
Oh, I do have a copy of the ordinance.
Right, yeah.
Do you want me to read that?
No, we're familiar with what it means. It's
Okay.
just that members of the public may not, they certainly can't cite the ordinance chapter and verse. So I just a friendly suggestion that it would be a courtesy to provide that in the future. But you did, I mean.
Oh, you mean the wording of the ordinance?
Right,
Oh.
right, or a summary of the wording.
Oh, okay. All right. Okay.
Are there other questions by members of the task force?
No, I'm fine.
Do I hear a motion for?
Well, you
or-
might ask her if there are any concluding remarks that she'd like to make.
Oh, I'm sorry. I'm really missing a lot of steps here.
Relax.
Okay. We've now reached the point where we can entertain rebuttals from, first of all, the respondent. Ms. Gong, do you have anything further you'd like to add? Okay. Is there anybody here who would like to speak on behalf of the complainant in this matter?
No, not this time. There's nobody in the audience.
Well, no,
Okay.
but just in case. Okay. Now, it's time for a motion.
Okay. Madam Chair, it appears that the order of determination has been met, and so I would move to. I'm not sure there's really no action. I move to find that the order of determination has been met, and that no further action on behalf of this committee or the task force is necessary.
I would second that.
Are there any comments from the public regarding this matter? Seeing none, Chris, would you call the roll? I believe we do have a formal motion.
I have a-
Or-
Yes. The motion is to find that the order of determination has been met and no further action by this committee or the task force is necessary.
Member Nee, could I ask a question? If I could make a comment about this case, is it now appropriate or after we voted, before we voted? What's the best time
Well,
for
if
me to
it's
do
pertinent to the motion, then it should be discussed.
Yeah.
It should be discussed now, I believe.
Yeah, so, as I said, I'm seconding the motion and I will vote for it. I think there has been compliance. But I just wanted to point out that there seems to be a misunderstanding in the office that this information was prohibited. Originally, there was a misunderstanding that the information couldn't be released. And I noticed in the email that you sent, you made clear that the information is being withheld as allowed under the statute, which I think is the correct interpretation. You are permitted to withhold it under the statute until the process is done, but there was some misunderstanding that the statute, or the ordinance, excuse me, doesn't allow the release of the information. And I think, as I said at the meeting the first time around, I think the statute permits the release of the information, and if you decided that you had wanted to do that, that would have been fine. And so I just want to sort of make that point and encourage the release of information when it's possible.
Chris, could you read the roll?
On the motion, Member Nee.
Aye.
Nee, aye. Member Snyder.
Aye.
Snyder, aye. Member Washburn.
Aye.
Washburn, aye. Madam Chairman, 3 ayes.
Chris, could you read the next item on the agenda, please?
Item number 6 is the hearing on the status of the June 22nd, 2010 order of determination in Ray Hartz against the Police Commission.
Mr. Hart, you have 5 minutes to present your case.
Members of the committee, I want to make one thing very clear. Again, we're not here discussing the fact that the police department or police, in this case, the police commission, did not have a posting on the index of records, even though when I did go there, it was gone. It was put back up. This is about the quality of what they have up on the record. At the June 22nd meeting, I discussed my concerns with it, and on June 23rd, I sent 2 letters to the Sunshine Ordinance Task Force with examples attached. And in each of those examples, it pointed to an item for this, in this case, where it said agenda notices, and you click on the agenda notices link, and what you get is a frame that tells you basically the same thing and gives you perhaps some information on how long it is retained and where. In all 3 cases, and then there's another link there where if you check it, it basically just takes you to a non-existent site. And in the letter, I'd just like to read one paragraph out of that. As presented at the SOTF meeting of June 22nd, 2010, it does not provide information, quote, under which manner of organization for accessing, e.g., by reference to a name, a date, a proceeding or project, or some other referencing system, unquote. Neither does it provide information as required by the ordinance to, quote, aid the public in making an inquiry or a request to inspect, unquote. And that is my issue. If you go to this, what you really find here is not an index of records, but is a listing of categories that the police department has placed records in. Like you have a category called administrative files. And, well, let me choose one that's actually the police commission. Correspondence. So unless they just have one big file and all correspondence goes into the big file, we don't know what's in there. We couldn't make a specific request for any particular piece of correspondence related to any particular issue. General orders. Those probably include all of the police procedures and policies, but how could I use this to make a request for a copy of a particular police procedure or policy since it gives me no information? It basically does not meet either of those two important criteria. One, that it give some sort of an indication of what the referencing system is, and number two, that it would be to the extent where I or you, as members of the public, if should we want to get information from the department, we could specifically ask for a certain document on a certain date or certain, or that to that extent. And really, I think it goes back to Matt Dorsey's comments when he was here at the 22nd meeting, June 22nd meeting, where he talked about the need to ask interrogatory questions of the people so they could determine what to give. Well, that unfortunately appears to me to be the case. These records do not belong to the employees of the police department or commission. They do not belong to the members of the commission. They do not belong to the city of San Francisco. They belong to the citizens of the city of San Francisco, you and I. And we should be entitled to have some sort of a way of referencing all of the records, of knowing what the police have. And it should be referenced in such a way that we can tell exactly how they're arranged and how they're organized, and in that process, we would then be able to request specific documents. What they have now is basically a system where if I want something, I ask for a certain piece of information, and they may know very well that there's a form that does have that piece of information, but since I cannot ask for that specifically, they say, oh, we don't have anything responsive to that request. I understand that the police department for 10 years, before I bought my complaint a couple years ago, had nothing on this website. Now what they have on there is basically meaningless. It really does not do any of the important things this required. Throughout the process of that hearing, we were assured over and over and over again that they understood, that they had read the ordinance, they had read this particular section, which they had been found in violation of, they understood what they were expected to do, and that they would do it. And then it was presented ultimately to the EOT committee that that had been done, and I think going back and looking, it has not been done. These records don't belong to anybody except the citizens of the city, and we should be able to know and have some way of accessing these records. We should know what the police department or police commission has, and specifically how to ask for them by name.
Is there anyone present who would like to offer facts and evidence in support of the complainant? Seeing none, the respondent has 5 minutes.
Members of the committee, good afternoon. I'm Lieutenant Joe Riley. I'm the Secretary of the Police Commission. I'm responding to the complaint before you this afternoon under item number 6. I will note for the record, I'll agree with the complainant that there was an order of determination last year in a matter, same subject. We tried to comply with that, and we did that by delivering an index of our records to the Office of the City Administrator through the City Attorney, who reviewed our submittal. The matter of the appearance of the record of the index was left with the City Administrator's Office, to whom the responsibility is delegated under the Sunshine Ordinance. I'll note that in looking at other index of records on the website for the City Attorney, the exact same format that we are being subjected to in terms of complaint appears for just about everybody else I could see on the city's index. The indexing that's done is beyond the control, the immediate control of the commission. You know, we like I say, we sent our list of documents that we retain through the City Attorney to the Office of the City Administrator for inclusion on the website, and this was the end product. So I know it's not satisfactory, but the format in which it appears is not under our direct control. I'll note also, for the sake of the complainant, that the department's general orders appear on the website, every single one of them with an index, and they can be read in their entirety at any time. The Police Commission records that appear are our agendas, our minutes appear on our site. They can be pulled up at any time. There's also a link to go to the particular commission meeting where the items were discussed. Any supporting documents for any of the items on our agendas is available from the commission office as a standard announcement in any of our proceedings. With that, committee members, I will leave it to your discussion. Unless you have any questions, ma'am.
Is there anyone else offering facts and evidence in support of the respondent? Seeing none, the matter's with the committee for questions and discussion. Member Nee?
Hi, Lieutenant Riley, please.
Yes, sir. I sat down too quickly.
Since the order of determination was issued, have you or anybody else representing the police commission gone over to the city administrator's office and apprised that office of Mr. Hartz's complaint, of the order of determination, and seeing if there's a way of maybe getting the index that we're talking about to be a bit more precise and informative?
No,
And you're saying it's beyond your control, but have you been to the city administrator's office to talk about the complaint and the order of determination?
I personally have not. I can't speak for the department. I know that when we created our index and delivered it with the department's index to the review by the city attorney and to the city administrator, it was, we left it in their hands to format. Not having consulted with my counterpart for the department, I couldn't really answer that directly. I think that if it hasn't been done, that's something that certainly can be done. But I know that you know, the index was posted after the last order of determination was up for a good year without any complaint or following. So I'm not quite sure what more we could do beyond your suggestion. And like I say, I'll have to find out if that was in fact done.
Thank you.
Lieutenant Riley? I just have a follow-up question. Mine's actually more basic, and you may have touched on this earlier and I missed it. I was trying to find my way through the specific part of the ordinance that governs this area. Can you, since the order of determination issued, has the police commission, I guess more generally, what have you done since the order of determination issued? What has changed?
Referring to the order of determination in 2009?
No, this order of determination that we're addressing here.
I'm not quite sure. Well, my next action after receiving notice of the order of determination was to appear as ordered by this committee. And here I am.
Okay.
Madam Chair.
Member Nee?
Yes, Lieutenant Riley, on the order of determination, you will note that it says, "The Commission's representative shall be prepared to demonstrate to the committee that the Commission's index of records enables members of the public to learn the types of information and documents maintained by and for the Commission per Ordinance 67.29. Are you prepared to do that right now?
No, sir, I'm not.
Thank you.
Members, it seems to me that I've given some thought about what an index means, and all of us are familiar with the index in the back of a book where we consulted to see where we might find some particular bit of information. And I'm familiar, I have looked at the index of records that was provided here, and I mean actually online as well as the paper copy. And this doesn't do the job. And I realize, I mean, we have the police commission here before us, but I think this is probably the case across the board. We have these indices of records posted, which are not in any sense of the term proper indices. They are lists of documents that are not clearly described such that a citizen could figure out what's there, and certainly there's no information about where to find something. So I think in this case, the police commission hasn't, in its oversight duty to see that this index is posted, hasn't done its job. Neither has probably anybody else in the city, for that matter. So we have a problem. We have a lot of information that we should be able to obtain, but no index on how to do so. So those are my thoughts about the problem in general and in particular for this order of determination.
And I would just add or comment that I think the fundamental issue here is that the police commission doesn't appear to have followed up with the order of determination and isn't able to demonstrate how the index does what it is required to do under the statute. And I think there is some vagueness to the statute. I think it's not entirely clear whether it's the city administrator's responsibility or the police commission's responsibility, but I think the order of determination was fairly clear as to what we were hoping to hear today, and I don't see that that has happened, with the exception of the violation we found under 6721E, which was sending a representative, which obviously the police commission has done, and we appreciate Lieutenant Riley's presence. However, I don't see that the order of determination was followed. Any follow-up was done.
Concluding remarks?
Now it's time for concluding remarks from first the respondent. You have 3 minutes to make any concluding remarks.
Nothing to add, Madam Chair.
Okay. Any concluding remarks from the complainant? Mr. Hart, you have 3 minutes.
Thank you, members of the committee. I wanted to comment on a couple of things. This also, I think, really, if you look at this index on the records, could come down to a question of whether they are business maintaining records in a business-like and professional manner. I mean, if this is actually what they're saying their index consists of, and that's what they use, I think that it would be hard as hell to tell exactly where it is. I mean, they got police substations, they have police buildings all over the city. I'm sure some of police records are probably kept here in the city, in City Hall. Who knows where they are? And this doesn't really tell you what they have or where they have it. One of the things that this section also talks about is the necessity to upkeep and forward to the custodian of the city any changes to the records. And unfortunately, I see in Lieutenant Riley's response sort of an opinion that, well, we did what we're supposed to do and now we can wash our hands of it. However, that is not the case. What is supposed to happen is if they have reorganizations of their records, they're required to upkeep the documentation and update the documentation on the website, whether it's through the city administrator or they're still required to send that. And really what they've done is they have not done anything in either respect. The real issue is, again, these records belong to the citizens of the city and county of San Francisco. They don't belong to the city government. They don't belong to the police commission. They don't belong to individual police officers. They are records that you and I, as members of the public, are entitled to see, with exceptions that are clearly laid out on the law. And if we need to request them right now, the only thing you can do, and I can tell you where this all started for me was 3 years ago, where I was trying to get information, talked to 20 different police officers, both at substations and at the headquarters, and got all sorts of responses, most of which were simply hang up, a lot of questions that they are not allowed to ask under the ordinance, and finally, officers getting to the point where they apparently had talked to one another and said, are you this guy, naming my name and saying, fuck you, and hanging up. And that's when I went to the city attorney's office and tried to get the information, because I figured, well, there's a city attorney there who defends the police department and probably has access to the same information that I'm requesting for the police department, and they wouldn't help me with that either. So really what you have, and going back to the one overall thing, yes, all of these are wrong. And I could have brought a complaint on every single agency of the city for this same complaint. I brought the police commission and police department because they were the most egregious. They didn't have anything at all. And now, you know, I am also bringing the same complaint against the city attorney's office because I believe city attorney is at the nexus of this. The city attorney has taken everything that has been submitted to them by the police department and other departments and dumbed it down to the level it's at.
Thank you. Okay, the matter is with the task force.
Madam
For
Chair.
a motion? Yes, Member Nee.
Well, before we make a motion, I mean, I think it's very clear that the order of determination has not been met, and it's not just the order of determination now. It's a question of, you know, the Sunshine Ordinance that was passed by the voters in 1999 makes very clear what the requirements are, and those requirements have not been met. But, and I'd welcome a comment on this on this line of thought from Mr. Hart and maybe from Lieutenant Riley as well. It's, you know, yes, it's clear that we could recommend to the full task force that this matter be referred. But what I'd like to suggest, just by way of discussion, is that perhaps we continue this item till next month and find out who at the city administrator's office is responsible for preparing and maintaining indices of records. Perhaps Lieutenant Riley could help us identify that person or those persons, that we bring them here and, you know, get them to tell us what they've done, what they've not done, what, if any, difficulties they have. You know, how can we move this forward? How can we make sure that the police commission and the police department and all other departments have indices of records that are something that the public really can use?
Yeah.
And I'd be interested in hearing from both the complainant and the respondent how they how that idea strikes them.
Ray Hartz again. I'm completely willing to do it in whatever way you feel will get the job done. My real concern is that there are numerous city agencies out there who seem to be holding public records as hostage. And you have to go through some sort of a long convoluted process to get it. And in many cases, because there is no way to actually find out what specific documents are available, you get bombarded with questions which are all inappropriate under Sunshine as to who you are, what you want, why you want it, and all these others. And again, Mr. Dorsey at his last appearance said the same thing. Well, we have to ask questions to understand what the person specifically is looking for. Well, that's also a way to keep control of the information. So if you feel that continuing this and going through the process where if the police commission and the police department offer to act in good faith and to actually work to improve this so that we get something there that is usable for the citizens of the city and county of San Francisco and helps them to know what these respective bodies hold and exactly what documents are there in a way that I could just request specific documents without having to go through what I went through, then I would be willing to do that in any way possible. What I am not willing to do, unfortunately, if going back to the first time we had to go around this, is to go through a continual thing where we're told, yes, we're going to do this, yes, we're going to do this, yes, we're going to do this. What we end up getting is something that really is not, I think, in any way responsive to what the section requires. And then it kind of disappeared off the website. And so I have to question whether or not is this going to be also something that I will have to continue to follow every few months to see if it disappeared. One of the things that concerned me was the response initially before the task force meeting saying, well, it went down, we don't know why it went down. And they made apparently no effort to find out why it went down. It could have gone down 3 days after it went up, and as a result could have been down for an entire year. Or it could have gone down 3 days before I went on to look for it, and it could have been up there most of the time, but not. So whatever you feel is appropriate that will get this index up there and get a meaningful index, I'm willing to work with you.
Perhaps Lieutenant Riley has some thoughts on this, through the chair.
Through the chair, if the committee's pleasure is as you described, I'd be very willing to cooperate in that effort. I think that, as I pointed out earlier, you know, we do not control the appearance of the index on the site. So, and when it did fall off and it was brought to our attention, I believe it was my counterpart who actually made the contact with the city administrator's office to have it restored. So we'd be more than willing to do that. I just note that in my 6 years at the police commission, I've never had a complaint of failure to produce or failure to provide or anything of that nature. People get the record requests usually the same day from us. So just note that in terms of good faith.
Thank you.
So, do we need a,
Madam Chair,
yes?
I'd like to move that this item be continued to the next regular meeting of the Compliance and Amendments Committee, and that continuation include instruction to the respondent and perhaps to our own administrator as well, to identify who in the city administrator's office is responsible for creating and maintaining indices of records, and that that person or those persons be instructed to attend the next regular meeting of the task force to be able to address this specific complaint, to provide and to perhaps use that as a starting point for examining all of the records indexes to make sure that they are usable to the citizens and that they comply with the ordinance, with section 67.29 of the ordinance. I guess that's a long-winded motion, but there you have it.
I think that's a great idea, and I would second that motion. Although with one point of clarification, you did say to attend the next meeting of the task force, but you meant the committee, right?
I meant this committee,
Yeah.
yes.
Committee, okay.
To attend the next meeting of this committee.
Gotcha.
Because we're, in a sense, dealing with a compliance issue specific to this case, but with broader implications. So at
Yes.
some point, we might go back, well, we will be reporting to the task force at some point.
That's correct.
Okay. Now it's time for comment by members of the public on the motion before us.
Kim Crossman, I'm okay with the idea of continuing it. I was thinking about how to solve this problem with regards to the clearly inadequate standard that's being currently used by the index records. And it came to me the best way to do this is to go to the library. They already have a great card catalog, electronic card catalog. When you want to look up to see if they have a certain periodical, you go and see, well, do they have this periodical in the past in their archives? It tells you which years, which issues they have, where it's located. Is it a microfiche, or it's online, or is it in a bound format? The libraries solve this problem of how to index information and make it readily accessible. And I think that should be the standard that's used in judging the usefulness of the index of records that's currently in place. The ordinance talks about some general ideas, but I think the spirit is that the information needs to be, clearly someone's able to quickly look at it and they identify if the record that they want is, highly likely to be in a location that's indicated. So I think the cataloging system that's used by a library should be used as a gold standard for what index of records should be compared against.
Any other comment by members of the public? Seeing none, Chris, could you call the roll?
On the motion, Member Nee.
Aye.
Nee, aye. Member Snyder.
Aye.
Snyder, aye. Member Washburn.
Aye.
Washburn, aye. Madam Chair, we have 3 ayes.
Chris, could you call the next item on the agenda, please?
Madam Chair, I'm going to call for public comment because it's 5 o'clock.
Oh,
General public comment.
general public, oh, I'm sorry. Item number 9, this is time for general public comment for items not on the agenda.
I think I'm just kind of asking a little bit about what happened to the meeting that was right before this one. Is that being continued till next month, or is it all the items carried over to another meeting, or what is happening? I think I also am wondering, how do I get like opinions from possibly like the city attorney or from this body regarding some issues instead of just bringing it to the full task force? I have some questions regarding passive meetings and listservs. So I'm just wondering, how do I get those instead of just trying to start the whole process up?
Sir, if we could address your questions. The prior meeting, are you referring to the complaints meeting? There was no quorum, so it's either being rescheduled or will happen next month. I don't know. Member Nee? It'll be August 10th. And regarding your second matter, I believe that you can bring, I would counsel you to bring these matters to our administrator, Mr. Rustam. He'd be happy to direct you or to someone who can answer your questions or answer them himself.
Okay, thanks.
Thank you. Mr. Hartz?
Yes, Ray Hartz. And again, I want to reiterate the fact that what I'm doing here is not any sort of a vendetta against the police department, police commission, city attorney's office. What I do feel is that looking at the response from Mr. Song, he said, well, we looked at the law, and we looked at the website, and we can't understand why Mr. Hartz would have a problem with what we have. And I'm kind of going like, okay, is this like willful blindness, or do they honestly really look at that and not have any idea? Unfortunately, having dealt with the rent board and a number of other city bodies, there seems to be some real confusion about 2 basic issues. One is that as members of the body, they have a right to interfere with people's First Amendment rights, to petition government for redress of grievances, and to free speech. Even though each and every one of you and each and every one of them took an oath to support and defend the Constitution of the United States and the Constitution of California, they seem to have gotten the idea that if they think that what you're talking about isn't something they think you should be talking about, or isn't being talked about in the way they think it should, that they have the right to arbitrarily override your First Amendment rights in the middle of your speech. I've had the Library Commission do it to me. And the second thing is that for some strange reason, city employees seem to feel that they can hold hostage public records, especially if you get into a case where you are, or someone else is dealing with them in some way. They can then withhold documents from you that you need to prove the case. In fact, in one case that has been before you before, after the first meeting, I told you that Mr. Ionin had told Ms. Tsang that he wasn't going to give her the documents you ordered her to. In a subsequent meeting, Brian Smith, the director of IT, went out in the hall and, because of my statements, looked around before he said anything, and he told Ms. Tsang, well, I have what you want, but I'm not going to give you what you want, and I'm not going to give you what you need, and it's what you need that you're lacking. So basically, they're saying, if I'm a city employee, I have the right in my job to withhold public records from you. And that is not correct. There's nothing in their job responsibility list or nothing in their assigned duties that says they can do that. In fact, they took an oath when they joined to protect the rights of the citizens and to defend the rights of the Constitution. Now, if I'm denied public documents that I need to make my argument, they're also affecting my First Amendment rights to free speech. because they have limited what I am able to say and present before government bodies, and bringing requests for redresses of grievance. So basically, the understanding needs to go out very clearly to all city employees: those records are not yours. They're not the departments, they're not the cities, they belong to the citizens, and if the citizens want them, you have no grounds whatsoever. One last thing I would like to say is, one of these days someone is going to catch on to this fact, and they're going to start suing these city employees as individuals, because they're not acting on behalf of the city, on behalf of the body. They're acting outside the bounds of the law on their own decision. And as a result, I don't think the city should be held responsible. It ought to be the city employee, and they start taking that particular city employee or board member to court.
Thank you. Any other comments from members of the public?
Hi, Keith Crossman. I would like to encourage the task force to start at least audio live streaming, if not audio and visual live streaming their meetings. They have the laptop that they can use. The webcams are free or extremely low cost, and they already have the internet connection. This is not something as easily done by the members of the public, because they don't have an internet connection here in the City Hall. And it's clearly the best way to show city staff that something can be done is to do it. And I think the task force could set a good example by pursuing the effort of doing live audio streaming rather than just posting the audio the next day online. Thank you.
Thank you. Any other members of the public here? I can't see. Okay. Chris, could you call the next item on the agenda, please?
The next item is item number 7, which is developing recommendations for the proposed task force electronic document retention policy.
This is something we've discussed in the past. I think it was probably back in February that we last heard from somebody from COIT about this. This matter is actually relevant to what we were just discussing in terms of an index of records. The key issue is, how does the public find what they're looking for? And retaining documents is one thing. Retrieving them from wherever they're retained is another thing. So, does anybody have anything to say about this matter? Member Nee?
Yeah, getting our arms around this whole issue is really quite difficult, largely because we're all volunteers here, and we don't have none of us individually has a lot of time to spend researching the area of best practices and the technology that's out there and so forth. What I would like to see eventually is that we develop a policy, a set of policies for the task force, and they could be used kind of as an example or a model for other entities within the city to follow. But perhaps, just for starters, one of the big issues that's been before us has been email. Preservation thereof, preservation of emails, deletion, backup, storage, retrieval, etc. of emails. And I'm just wondering if it might not be possible to get somebody from the Department of Technology here next time around, to our next meeting, find out what is and is not possible in terms of email storage and retrieval, storage, backup, and retrieval, and develop a policy around that. Just for starters,
right.
Just take it one at a time and develop this, as we're able.
Right.
Maybe that's a good way to start.
And I know that apparently the city has changed the email program that they were using.
They're in the process, I believe, of shifting from Lotus Notes to Microsoft Exchange.
Okay.
Although I'm not sure that that's universal. I think it's on a department by department basis, and some departments. I think one of the things that come out at the Committee on Information Technology meetings is I think there is a desire on the part of the people putting this system together to create unified policies and parameters and so forth. But I think there's also a question of what works for one department might not work best for another. And I think this is an issue that they're kind of trying to get their arms around. So maybe somebody like Richard Robinson or Chris Veen or both of them could be invited to appear at our next meeting and help us to figure out what we can do, at least for starters, at least, what we can do in the email area.
Right. I think that's a good idea. So Chris, if you could contact them and ask that they attend, that would be great.
And if they, if they want to suggest somebody else who might be equally or better suited to give us what we're looking, the kind of information and insight that we're looking for, certainly anybody else that they want to suggest or bring along would be fine.
Chris, would you call the next item on the agenda, please?
Item
I'm sorry, public comment on.
Public comment, Kim Crossman. I want to say I'm very disappointed in Task Force. This issue has been bandied about for over 2 years. All you had to do is say, Chris, start preserving all the emails for X number of years or days or whatever it is. Has not happened. This is not a technological issue. Don't have to learn anything about technology. Just roll out the policy, and then they will find the technology to make it happen. San Jose already has 5 to 10 year preservation of emails. State of Missouri has 7 years. They set the policy, and then they made the technology department implement the correct technology for it. Brokerages already have to preserve email for 7 years due to SEC regulations. Therefore, there's no issue about the availability of technology to solve this problem. I just want to say how disappointed I am with the task force for not taking this matter seriously. Let's remember, deleting email is withholding records. If a department deletes the email, the record can't be retrieved, and therefore it's withholding the record illegally. This is not a policy for the other departments to consider. It's a requirement the task force should roll out to all the departments, requiring all departments to preserve their email, because otherwise it's withholding records. That's illegal. So the task force is way behind in leadership on this matter, and I have no feeling that it's going to change. Department of Technology will come here and tell you how, oh, it's so expensive, or because they don't want to do it. They don't want to preserve emails because people don't want emails to be preserved. Emails are embarrassing. So I am a short item on here talking about what might happen after you've been talking about for 2 years with the whatever. Seriously.
Are there other members of the public to comment on this matter? Seeing none, Chris, the next item on the agenda, please.
Madam Chair, the next item is the administrator's report. I have nothing to add besides there was one complaint withdrawal this past week. And Chair, if the task force chair might consider putting an item on the task force agenda to change or get a new venue or time for the next complaint meeting, because it's going to, the agenda is going to be very lengthy.
Well, I believe that that would be up to the complaint committee chair, would it not?
Yes, but since he is not around.
Well, I mean that, how many items on the next complaint committee
We're
agenda?
looking about 10,
10.
and we have only a time frame of about half an hour.
Well, what I would suggest is that you look for, how early does this room become available? Do you know? On the second Tuesday?
There isn't any set times on the availability. Sometimes they have, sometimes the meeting ends at 10 o'clock, 11 o'clock, 12 o'clock, 1, 2.
Okay, when you say that the chairman is not around, how long do you expect that to last?
He did indicate in his email that he won't be here for this meeting and for the task force meeting. Chair Nick Goldman.
Okay, will he be totally incommunicado?
He did not indicate that, Mr. Chair.
Okay. Let's do this then. What we could do also is lengthen the, have the complaint committee meeting start at its regular time and put the compliance and amendments committee meeting back by an hour to an hour and a half.
Have it start at 5 o'clock?
Have it start at 5 o'clock.
Okay.
Call for a special meeting then. Cancel the regular meeting and call for a special meeting at 5?
Well, couldn't we hold the regular meeting at 5?
Because the regular meeting is held at 4.
Well, okay. Then cancel the regular meeting of the Compliance and Amendments Committee and reschedule it as a special meeting at 5 p.m.
Do we need to run this by Jerry Treat or Joanna Clark?
Couldn't hurt.
Okay, I'll do that tomorrow then.
And also let the other members of the complaint committee know that this is happening. Chair Goldman and Member Knebber.
I certainly will do that.
And make sure, did you say Member Goldman will or will not be at the next complaint committee meeting?
Chairney, I think you may have to send me that email again, because during the 5 minutes I was over there at my desk, I could not find it.
So he's gone today, and he will not be at the next task force meeting.
That
But
is
we have to ascertain
yes.
about next month. Okay, we can do that. Just let him, keep him in the loop about what's going on.
We'll do that.
And we need to make sure that Member Knebber can attend Member Knebber will not be here, will not be at the next month. So this means then that if we have to first we have to ascertain whether Member Goldman will be here next month and go from there, because if Member Goldman cannot be here next month, we need to find an alternate time and date and maybe venue for the next meeting of the complaint committee.
What are the dates of next month's meetings of this
month's
committee and of the
August
task
10th.
force?
It will be the 10th of August.
Okay, great. And then the task force meeting next month?
Next month
It's
would be
24th?
August 24th,
Great. Okay.
but the task force is to meet this month, July
Okay.
27th.
That concludes whatever I have to say.
The last item on the agenda, please.
Last item is the announcements, questions, and future agenda items, Madam Chair.
Does anyone have anything further?
I have nothing.
Okay. Do I hear a motion to adjourn the meeting?
So move.
Second?
Without objection?